Okay, so thank you, Tauri, for your kind introduction. So it's good to be back to Hong Kong U again. I think this is the 10th lecture that I'll be giving at SMU. So I'm very glad to come back again. So actually, this topic is very marginal. So no IP lawyers is interested or care about this issue, and no criminal lawyer professors care about this topic either. But however, I think this might be perhaps one of the key aspects that has been overlooked when we look at the differences between the Eastern and Western IP development. Now we have a standard a harmonization through TRIPS. So on the faces, national IP regimes look a lot the same, but I think in practice they still differ. And in this respect, I think it is worth exploring the impact or the role that criminal enforcement of IP has played, especially in this part of the world. And what we can learn from this, whether we can then have some feedback, meaningful feedback to the international community. And this is actually a book project that we have developed over the last 2 years. It started actually has a very humble origin. It was a co-drafted chapter for the Festschrift for Professor Retter-Hütti when he retired. But then I said, well, this is actually very seminal. It is very potential. Why don't we develop further into a full book? So now it become a book project accepted by OUP. Okay, and my job as editor of this book is really try to then summarize some of our finding and then come up with some policy suggestions, and not only for Asian economy but also for the WTO and also for leading countries. Of course, this is very ambitious. Okay, I think before we start, we need to ask ourselves the following questions: that why do we then criminalize the IP infringement in the first place? Is it because it is a semi or quasi property, therefore whatever applied to property right and can equally be applicable to IP, or there are some different issues involved, namely people or country want to have a quick fix to a problem that they don't like, or they simply want to have some deterrence, or it is simply as a result of trade pressure from outside, or it is actually nothing but the result of lobbying groups' efforts. Okay, so then we all know TRIPS is the only thing that we have, which says that in Article 61, they ask members to introduce criminal punishment for willful trademark counterfeiting and copyright piracy on a commercial scale. Okay, this is pretty much what people have agreed in 1994. A further agreement consensus simply was absent. So then, does that mean then willfulness plus the scale of commercial scale equals mens rea that is normally required of any criminal sanctions? And then shall we then on which similar crime should we then benchmark these IP crime? Is it something similar to theft, or something similar to trespass, or something similar to vandalism? I think IP professionals, we never ask ourselves this question. We just go along. We just play along. We don't really ask ourselves these questions. And then actually, what punishment is the most optimal, ideal instrument for achieving goal? If there are any goal to be achieved, is it fine, or is it fine alone, or fine plus imprisonment? And then how long should this imprisonment be? And also, how about public shaming, asking the publications of guilty verdicts? And then we also have to ask ourselves, do we have then consistency, coherence across all IP laws? I think in most jurisdictions that we survey and study, there's simply a lack of consistency and coherency. you just the thing happen quite arbitrarily. Right. So I think the actual even overuse of criminal enforcement for IP might be one of the dividing point between East and West, and we want to explore why there's this difference and what impact will this difference on the actual development of IP have. This is then our goal. So before I start, I will give you another contrast, a very simple German example, because I got my degree from Germany, so I know a thing or two about German law. So to my own personal surprise is that they are very restrained in the use of a criminal punishment. So the maximum criminal punishment for any IP law is only five years. Okay, in serious case, for first offender is 2 to 3 years. It can be increased up to only 5 years. So it is universally so, and eventually that can be replaced by a fine. Okay, you don't have to go to jail. You can walk free if you have money to pay the fine. So this is very different from Asian criminal IP law. It is very lenient. It is very rarely enforced, okay, and they don't necessarily want to put people behind bar. You can pay a fine. But in theory or in a law in books, okay, then you see every IP law from the very inceptions of their respective IP law, they have criminal punishment. Okay, but very interestingly is that they never actually put them into practice. So in other words, they don't use criminal punishment as a deterrent for them to enforce their IP law. So as I mentioned, so every IP law has criminal provisions, but then the maximum penalty is up to 5 years, and it can be then replaced by a fine. So without boring you with this detail, but I think this is the overall picture. And every law, the semiconductor law, the new plant rights, every law, and the trade secret protection law, every law you have criminal punishment, but they are mild and they are rarely put to use. But there, as I mentioned, there are two specialties about the German fine system. Okay, the fine can be prohibitively high, so they have the so-called daily rates, Tagessätze. So then it's between 5 and 360 full so-called daily rates, depending on how much you can earn. So you can start from earning just €1 per day and up to 30,000 euro per day. So then the maximum. So the fine is then has a great range. It can be just €5, or it can be up to 10 million euro. That's actually a lot of money. And this actually, before I embarked on this study, I didn't realize, wow, this is very, very different from Asian law. In many Asian jurisdictions, we have draconian provisions. It is up to 15 years, and then plus a fine. You cannot walk free without just paying fine. Right, and then in German jurisprudence, actual legal practice is that they never actually let criminal law go first. Whenever it is possible, then the criminal prosecutions and criminal court decisions will always wait for the civil courts, civil parts of it to be solved first. So they have this mechanism of statutory principle of criminal prosecution following civil law or administrative law principle. Right. So the criminal courts will await civil law decisions, and the Ministry of Justice, they have a guideline for public prosecution. So as a principle, they don't intervene into private disputes, even it concerns IP. So it has to involve the public interest. So there was this guideline saying that, well, if it comes to IP, then they will be especially assumed when the defendant was a repeated violator, okay, or there's significant damage or impending or that has already happened, or that the act threatens the economic existence of the infringed, or public security or the health of the consumer is in danger. So in these serious cases or situations, or only then will public prosecutions be activated. But as I said again and again, rarely is this actually activated. So then, if you read the German Kommentar, as I do, they pretty much say nothing about the actual criminal cases, because simply there's none. There's literally no criminal cases, right? But of course, there are some cases for trademark counterfeiting and phishing and product piracy, typical cases. Right. So again, as I said, this is rarely employed to protect even trade secrets. So here in Asia, the very interesting development in the last 10, 20 years, that we increase criminal punishment for trade secret misappropriation. So in Korea, it's up to 15 years if it is economic espionage, which is a cross-border trade secret misappropriations. In Taiwan is above 5 to 12 years, and China is 5 years above to 20 years. But in Germany, the maximum is only 5 years. Okay, and as a matter of fact, they don't apply criminal law to retain or threaten a leaving former employee. So if you are experienced enough, you know that most of the cases that involve trade secrets was then conducted or was associated with the employees. So it was mostly done by leaving employee. It was never done by 007. Okay, so we don't want to over penalize people trying to switch their job. Okay, so Germany represent a very different model, very lenient, very mild. They don't believe in the criminal enforcement of IP. Here in Asia, I'll give you some example. I will not be able to cover them all, but Japan is a very interesting case. So from the very beginning, they all also introduced criminal provision into each and every its IP laws. Okay, and beginning from 2003, they have unified all this criminal punishment. So it can every criminal IP infringement can be subject to imprisonment up to 10 years. Okay, so no matter which kind of IP infringement, so they don't differentiate between copyright infringement, trademark infringement, and patent infringement. No, so every IP law infringement is subject to 10-year imprisonment maximum. This is pretty much the German model. Okay, so they still have criminal provision like Germany, even for patent infringement, of course, but they rarely enforce. So then you have criminal enforcement for unfair competition, unfair trade practice, such as again trade secret misappropriations, and one thing very special about Japanese criminal system is that while they have almost 100% convictions rate, right? Pretty much, I can give you actual examples, and then so the very fact that you are being investigated by the police, and the very fact that you are being investigated by the public prosecutor, then that already send out a strong signaling effect, suggesting that while you are somehow not entirely law-abiding, right? And so very interesting to see the chapter written by Professor Suzuki on Japan is that He thinks that in the last 20 years, there seems to be an increase of criminal enforcement of IP in Japan due to the fact that the civil enforcement of IP is not as expected as we expect. Okay, there are reasons for this, but we don't have time to go into the detail. But of course, understandable. The civil part and the criminal part will have a trade-off effect. The more one is, the other will be less in demand, right? So they complain that there's weakness in the Japanese civil IP enforcement regime, and I talked about then the people then started to switch to criminal enforcement because there's this high convictions rate up to 100%. And that's why they can have very strong chilling or intimidating effect on the creative business part of Japanese industry. So if you look at the statistics, so we tend to think, well, Japanese are very law-abiding; they never violate the law, but this is not the case. And we thought, well, they don't over-prosecute, and they leave people be, and they don't want to intervene that much. But if you look at the statistics, so the first statistics are cases where prosecution has filed indictment, and the right is the number of where prosecutor decided to drop the case despite the fact that they have conducted investigations. So then there are still substantial numbers of cases where public prosecutions has initiated the investigations and evidence gathering process, but then at the end of the day, they decided to drop. And this is especially the case in Unfair Competition Preventions Act, which deal with trade secrets. Okay, they have even more cases where prosecution decided to drop their prosecutions. So then, if you then look into these substantial number of criminal cases, parties that are involved, and you can imagine these must have very strong smearing effect and chilling effect on those people who are involved. So this is the case in Japan. And then a trade secret case in Japan, very interesting empirical study. So then there are some 30 cases between 2003 and 2020. So for a period of 20 years, there are only some 30 criminal cases involving trade secret misappropriations. None of this has to do with cross-border trade secret misappropriation. So 007 again was absent. Okay, so the absolute majority of cases, 28 out of 90 cases involve a former employee. Okay, so then as I said. Even for Japan, Japan is the only net exporter of technology in Asia. Okay, and they have limited cases for trade secret misappropriations, and not even one for so-called economic espionage. And these 30 cases, they all were found guilty as charged. Right. And in Japan, very interestingly, they are very unforgiving. Okay, so the criminal punishment is up to 10-year imprisonment, and they can, public prosecution, they can initiate ex officio investigations without complaint filed by the party, except in Copyright and Unfair Trade Preventions Act. So they are very draconian, very different from the rest of the Asian regime. So Korea, they have all IP laws have criminal sanctions, and they criminal enforcement is the prevailing method for IP enforcements. But we don't have the actual statistics yet. But then if you look at the statute itself, as I mentioned, cross-border trade secret misappropriation can be then subject to imprisonment up to 15 years. This is really too heavy a penalty. So if you then compare this to theft or vandalism or trespass, this is far too heavy, right? And then, of course, criminal enforcement has become rare for patents, but then there are a major mechanism for IP enforcement. In terms of economic espionage, they found some cases, but actually the sentence or the term that they were given was relatively mild. So again, this story about economic espionage that will bring the catastrophic damage to national economy is at least has not been proven yet, not in Japan, not in Korea. Right, and Taiwan, very interestingly, is that we now have more criminal IP cases than civil cases, right? Right. So let me show you the statistics. The first instance, civil and criminal IP cases are in Taiwan. So clearly you see that there are far more copyright, trademark, criminal cases than there are civil copyright and trademark cases in Taiwan, because criminal enforcement becomes very handy. You just ask public prosecutor to do all the thing for you. Okay, they can collect the evidence for you. They can arrest people, and after winning criminal cases, then you file an adjacent ancillary civil cases. You don't have to pay court fees if that in that context. So that become a common practice, standardized practice in Taiwan. You first file criminal lawsuit, and then after winning the criminal part of it, then you file for civil damages. But the good thing about Taiwan is that we abolished criminal punishment for patent in 2003 due to the strong lobby by TSMC and MediaTek, the two tech giants in Taiwan. But then we, again, under the U.S. pressure, we increased criminal punishment for trade secret misappropriation, especially in a cross-border context. So we even then revised our National Security Act to deal with issues that are cross-border in nature. So then if the if the trade secret involve a national core key technology, then cross-border trade secret misappropriations will be then subject to 5 to 12 years imprisonment. That is very harsh. But again, in reality, you see this disparity between actual judicial practice. Judges don't like harsh penalty. Judges find it difficult to apply those harsh criminal penalties to mostly people who are simply engineers. Okay, they just try to switch a job for better payment. Especially in terms of trade secret misappropriation and things like this, you at least my study shows that actually few people got convicted at the end of the day, despite all these fanfares and the dawn raids and media coverage. But at the end of the day, there are only very extremely a few cases. The indictment rate is only 25%. So that means 3/4 of people will walk free, and those there are only some 16 convicted cases, and without exception, these 16 conviction cases all come with probations. So no one really go into jail because of trade secret misappropriations. So then you see clearly there's a disparity between statutory law that oftentimes are result of trade pressure or interest group lobbying, but in actual rendering of criminal punishment, courts think very differently. They simply don't like this harsh penalty. So there are cases that I've studied, and then they all come with the probations, right? But very unfortunate, as I said at the beginning, that there are far more criminal IP cases than civil cases in Taiwan. So then people, at least people like myself, sometimes we got very confused about courts' decision and courts' interpretations of IP laws. So they, so to speak, put IP law on a martial law kind of perspective, and not really interpreting IP statutory provisions from the very rationale of IP law. Rather, they are led by many considerations of deterrence or punishment or social disapproval, thing like this. But that really has little to do with the IP as such. So China then it seems to be catching up. So beginning from 2020, they also have a harmonized criminal punishment for IP crimes. It's between 3 to 10 years. Okay, that's not lenient. And if it is then yes, if it is then cross-border. Sorry, this is still in Mandarin. But if it is cross-border trade secret misappropriation, then the minimum punishment is 5 years, and it can go all the way up to 20 years. That is very, very draconian. But one good thing about China is that although they have a huge number of civil IP cases, 2.5 million first instance cases between 2013 and 2021. So making the Chinese IP judges the most experienced IP judges on earth, right? They have to chop them off just like they're chopping cabbage. So they are extremely efficient. But the number of criminal cases remains stable. So in other words, people haven't instrumentalized a criminal punishment as a mean to enforce their IP rights. Okay, this is one good development in China. So then you see the criminal cases for trademark is quite stable, around 5,000 cases per year. There are some 300 copyright criminal cases. That number is very stable. I very much hope that they can maintain this good track record without following the example of Taiwan. Right. Yes. Okay. So then I think the ideal case when it comes to Asian jurisdiction is pretty much Hong Kong. Hong Kong exercised the utmost self-restraint in putting people behind bar in terms of enforcing enforcing IP law through criminal punishment. No, they recognize only criminal punishment for trademark counterfeiting and copyright infringement, and no other thing else. Right. Okay. So this is a chart. So it shows that, well, the leading country, they have the most comprehensive coverage of criminal punishment. Germany, Japan, Korea leading, and then but then the difference, the actual difference is that here you do impose criminal punishment, and sometimes, especially in Taiwan and Korea, India, you utilize those criminal punishment. Right. So again, when we talked about policy analysis, then we have to bear in mind that while in the Asian context, we have a different social perceptions about crimes and punishment. So the principle of presumptions of innocence until being found guilty is not the rule here in Asia. Pretty much starting from Japan to Southeast Asia or to India. So criminal punishment bears certain social pressures on any party that will involve in criminal cases. And then I think to begin with, is really, I don't think the criminal punishment is ideal instrument for enforcing IP, but because we all know that, well, in order to deter people or in order to guide people's behavior, you have to set very clear rules from the very beginning. But then this is not the case for IP infringement. Every IP infringement takes time to determine. You have to, at the end of the day, do the overall assessment, whether the two objects are confusingly similar or whether they are of substantial similarity. I think like this, so involves a lot of ex post assessments, okay? And this is something you cannot tell in advance. So I would even argue that, well, IP is the poor instrument for, I mean, criminal law is a poor and wrong tool for enforcing IP rights. And the jurisdiction that we study, we then clearly see this inherent arbitrariness in how people criminalize the IP laws. They don't follow any rules. They don't have criteria. They just haphazardly decide, well, we think we should punish the copyright infringement more heavier than we punish the criminal infringement for patent and trademark. So this is the case in Taiwan, but it is not the case. This is the opposite the case, and in Korea, they punish the so-called industrial property right infringement more heavier than they punish copyright. Why is that? And in Malaysia, then, if you then provide service to circumvent technical protective measures, then you can be then subject to 20 years imprisonments. Again, why is that? Nobody knows. It just happens. So oftentimes it happened under the trade pressure, or it was the result of interest group lobbying. So the parliament, they respond to social pressure instantaneously without really reflecting on the merits of it. Right, so then, as I mentioned, in Korea, infringement of industrial property rights, okay, are punished heavier than copyright infringement. But in Taiwan, this is the opposite around. Why is that? We don't know, because we don't care, right? And also, at least for me, I think some of the IP crimes are very difficult to determine, okay? Especially trade secret misappropriations, that you have to determine the intent, and also you have to determine whether this is intended for use in domestic jurisdictions and foreign jurisdictions. But in a globalized world, so how do you then differentiate between that intention and also make the differentiation between a local and cross-border jurisdictions? It is very arbitrary. And yes, another issue with criminal enforcement of IP is that it has very strong chilling effects on expressive activity. So there are, well, we all know the fan works are quite popular, not only in the UK, but also in Japan and in China, or parody, things like this. So these all are based on existent works. So if we then over penalize people for making use of existing works, that actually can have very strong chilling effects on creative, expressive business. And also we see people gaming the criminal punishment system for personal gains. Here I gave you one example in Taiwan. So there was an online sale of second-hand branded goods. Okay, but the buyer got 100% refund after claiming that, well, you people sold me fake LV bags. But the buyer was 100% fully funded because it was transactions through Shopee platform. So there was no actual harm caused. But still, the buyer can initiate via criminal complaint to go after the two sellers, okay, two ladies. So they were embroiled in criminal punishment cases for over 2.5 years. And this is a good example where people can game the criminal punishment system to make personal gains. And also, when we talked about even TRIPS Article 61 talked about deterrence, right? They must have sufficient deterrent effect. But then what do you mean by deterrence? Then do we have to look at it holistically? So it's not just about imprisonment, but also there are other consequences, right? Civil, administrative, and punitive. So then if you add them all up, actually they are not only a double jeopardy, there are even triple damage, even quadruple damage, because then in many jurisdictions, then you have administrative fine. This is the case in mainland China, also in Germany, up to 50,000 euros, and then you have statutory damages, and some in some jurisdiction in China and Taiwan, we recognize punitive damages, right? And also we can then confiscate the infringing goods, and then we can publicly shame the violators. And these, if you all add them all up, actually these will be pretty much too much, I would say. This is draconian. And if you follow the European principle of proportionality, you don't over penalize people for one single crime. So there's this just very recent CJEU case involving a Bulgarian criminal provision, which says the minimum punishment for if I'm not mistaken, for trademark infringement is 5 years. Okay. At the end of the day, the CJU said, "No, this is not in compliance with the principle of proportionality," because then judges are tied in their discretion. They cannot render criminal sentencing less than 5 years, but then that can be disproportionately harsh for individual cases. I think there's this serious issues of the double, triple, quadruple damages for IP infringement. Okay, so then we try to put forward some suggestions. Okay, again, this is very typical people for people trained in the civil law jurisdictions. Okay, we like to deal with bigger issues. We are different from common law lawyers. They just want to deal with individual cases. Okay, no, we are not satisfied with with dealing with individual cases. We want to put forward grand theory and or a larger scale kind of reform. Okay, so then I suggest, or we suggest, we make suggestions to Asian economy where we know a bit better. We also make suggestion for so-called IP leading economy. We also make suggestion for the WTO community. Yes. So for Asian economies, that we would urge them to bring their criminal punishment for IP infringement in alignment. You have to make it coherent, okay, consistent. Not that you overshoot, that you over protect, right? And also, I think we can incrementally decriminalize many IP crimes, which are actually very technology specific. Okay, these are actually easily outdated by new technology. And also we suggest criminal procedure should follow a civil procedure, and perhaps actually the fourth suggestion is that perhaps we should really start from fine first. But if you read the criminal procedure, they always start with imprisonment. No. I think we should start first with fine. You deplete their illicit or unlawful gains. That actually is in itself a strong deterrent. And so, and sometimes fine alone will do the job. Okay. Then what is then our suggestions for leading IP economy? Actually, we are targeting the U.S., for example. They should refrain from pressuring their trading partners into more or heavier criminal enforcement. So if you read the first stage U.S. and China trade deal that was signed in 2020, you will feel very much appalled by the provisions. So it's interventionist. It's just dictating everything to China. Are you people? You should use the maximum criminal punishment for IP infringement, and you should then increase your criminal punishment for IP infringement. Wow, this is something you don't say, you don't do. This is a very, very imperialist, right? This is something you don't do. But I don't want to go into politics. And yes, and then for the IPW community is that I think we should perceive Article 61, the crime for willful trademark counterfeiting and copyright piracy as the ceiling for any criminal punishment. So national members of the WTO, you have the discretion to decide how severe you want to punish these two specific crimes: willful trademark counterfeiting and copyright piracy on a commercial scale. It is up to you to decide. But once you set that criminal punishment for these two crimes, specific crimes, no other crime should going above the crime that you have set, because I would perceive Article 61 as the ceiling. This is what we people have agreed upon in 1994. We shouldn't go beyond that. And also we need to return to the basic principle of modesty and constraint of criminal law. And this is something easily understandable in Asian economy, which was heavily influenced by the teachings of Confucius, right? 中庸之道 or golden middle way or harmony, thing like this. Oh, with that, I will just conclude my presentation. I look forward to a interesting Q&A session. Thank you.